It's long overdue to give you an update about the Biomet metal-on-metal hip implant litigation. Most people think that the Biomet implant litigation is over. A couple years ago, there was a very large settlement of most of the Biomet M2A Magnum cases, but the case is not over. The leadership that negotiated that last settlement is basically out of the case. The judge in the case has appointed new leadership. My partner, Brenda Fulmer, has been appointed as co-lead of that litigation, and there are still 300 cases pending in the MDL action as we speak. One of the most recent developments in that litigation is that the judge has been convinced by current leadership that bellwether trials in the MDL are unnecessary. That was a point that was made by leadership for the plaintiffs, and unfortunately for them, they carried the day. The track that we're on now in the Biomet litigation is to have the judge preside over case-specific discovery of a track of cases that involves 50, and then once that case-specific discovery is over, to remand those cases back to the courts from where they came so that they can be tried by the transferor court. That is also another big development because Biomet, essentially since the beginning of this MDL, has wanted to keep all the cases in the MDL. The judge has also, in his most recent order, established 2 other tracks for cases. Biomet has taken the position that many of these cases are barred by the statute of limitations. And so the judge has accepted their argument and put a select number of cases that Biomet wanted on that track to be worked up just to the point where the issue of statute of limitations could be decided as a matter of law by the court. And those that can't be decided as a matter of law by the court, those cases ultimately will go into a discovery track and then be remanded for trial. The judge has also established a 3rd track in addition to the active discovery track for the 50 cases for case-specific discovery and the statute of limitations track. The judge has established a 3rd track at Biomet's urging, where Biomet is contending that the plaintiffs did not handle the explanted devices in a proper manner, basically claiming spoliation of evidence. The judge has accepted that argument and allowed Biomet to put some of the cases that are in the MDL on the track to be looked at to see whether or not the plaintiff in fact has violated the court's preservation order, and so that might or might not dispose of some of those cases. What really is the most important takeaway for Biomet these days is that the litigation is still alive and well. The judge is considering right now whether to reopen discovery against the company. The judge has established 3 tracks to move these cases down the road, including a specific discovery track on 50 cases that we can anticipate a reasonably prompt remand on, which will result in trials happening against Biomet all over the country as opposed to in the MDL itself.